In almost every consultation that we have, I find myself totally surprised because folks ask questions that to me are basic. They are already ingrained in my mind. I know exactly what the answer is, and to me it is second nature. Some of these questions are like Divorce 101, FAQs. And I sometimes need to realize more. As I've stated before, people are not educated in divorce or family law. Why in the world would they be? There is no Divorce 101 in college or graduate school or high school. There is no Family Law 102 unless you're going to law school or unless you are a pre-law student. Some local schools have fantastic pre-law programs. I'm not even sure that they cover the intricacies of these things because it may be more preparatory than practice-oriented. The thing that shocks me the most, there are two of them. In fact, one is child support, where everybody believes that if they have 50-50 timesharing, even if one party earns $1 million and the other party earns minimum wage, somehow 50-50 timesharing translates into no child support. It is a myth. You cannot waive child support in the state of Florida. The one exception is if both parties agree the amount is de minimis. And even then, what is de minimis? In other words, what is close to zero? Is it less than $100? Less than $50? If your child support obligation is $200, $300, $400, $500 or more, there is a very slim likelihood the court is going to waive your child support. The other one is this. Most people watch these divorce shows on Netflix, and there's a new one called Divorce Court. There's one called Divorce in the Black. And these shows may be highly entertaining, but I would caution you that these shows are strictly entertainment. These shows, sort of like Judge Brown or Judge Judy, used to be Judge Wapner when I grew up, and I always remember the music when the litigants were waiting and the bailiff and the post-mortem interviews of what happened during the proceedings. That divorce court is not like that. Divorce court is not small claims court in county court. Most divorce courts are what we call superior courts or circuit courts. Divorce court is a higher court, essentially and inherently, because it deals with high-level financial issues of the utmost importance to the parties, and it deals with custody situations and child support enforcement involving minor children. What shocks me the most is when folks say, well, I'm going to go tell the judge this, or the judge is going to know this, or the judge is going to hear that. In most family law cases, unless you file an additional motion, you schedule it for a hearing, you appear in court or on Zoom or Teams or WebEx, whatever the court provides or prefers, there is a slim likelihood you're going to meet the judge. And if you do, and this is a pre-trial issue, it is more likely than not one of enforcement, which is a short hearing, 30 minutes to an hour, or perhaps it may be an issue involving compelling discovery responses. Those hearings are 5 to 10 minutes, sometimes 15 minutes. Your exposure and time before the court is extremely limited. This is not a circumstance, even if you were at trial, where two people are talking over each other. Well, he said this, well, she said that, well, he did this, well, he did that. It's more organized than that. It's counsel-driven. We ask you questions, the other side objects or not. The other side asks you questions, and we object or not. They present evidence, they try to lay a foundation, they try to get evidence in. We might lodge some objections if it is improper, if what they are asking might be based on hearsay, as we call it. Whatever the case may be, we are ready to make the proper objections or demand the proper procedural aspects be followed. But again, that is not what you see on television. Well, he stole my book. Well, when she stole my book, she wrote in it and she defaced the pages. That is not what we are doing in family law court. Family law court is a lot more high level than that. It is not the boots on the ground, as they say. It's more a 30,000-foot view. It's more tame to an extent. The questions can be nasty and brutal inherently if somebody's neglectful of their kids or not paying child support, but it's not the type of proceeding where it's tit for tat, where we're launching haymakers at each other for 5 minutes and then the judge issues a quick decision. Many family law trials take a day, 2 days, or even a week. So we're not talking about small claims procedures. They have very little in common. I believe it is important for people to recognize that family law, divorce law is high level, highly technical, and it is not just based on the facts, where one party presents all of their facts and the judge is definitely going to see things my way, and the other side thinks the other side's terrible, what a bad man or a terrible woman or a narcissist or whatever, and I'm going to tell the judge, and the judge definitely is going to see through it. Things are not quite that simple. Even if a judge, quote, sees through it and sides with you entirely and believes that your argument is foolproof, that your argument is beyond reproach, the judge is still beholden to follow the law. In Florida, we have statutory law and case law precedent. You might be absolutely right in your mind on an issue, but the facts that you present go against you based on case law precedent in your own district, or maybe because of a decision by the Florida Supreme Court. Try not to envision family law court as the place to launch grievances. Try to view family law court as the place to put forward the best arguments that are logical, reasonable, evidence-based, the best arguments to support your cause, your rationale, your reasoning, and understand that it is also very intellectual. It is also supposed to be for those that know how to speak clearly, concisely, and understand your audience well. Do not envision this as I'm going to get revenge. Do not envision this as I'm going to be the loudest. Try to understand. Family law court is not about those things. This is not a lower court. This is not a civil action. This is a family law action. And the rules and procedures are their own, and they are quite distinct. Thanks, everyone.